So good morning, everyone, and thank you for being here for our webinar CPD talk on arbitration in the context of the construction industry, presented by Reshma Oogorah and a fellow of the FCIArb, founder, international lawyer, and arbitrator. So thank you for being here, everybody, as we look forward to get on with the webinar today. So quick agenda as always, and quick housekeeping as well. We'll have introduction, a quick survey as we do, presentation part one. There'll be some survey discussion just to make sure that we get all of you engaged in the presentation today. Part two presentation, a quick survey as well, and then part three as well. Again, a bit of survey, and then finally we'll conclude. So again, these are the agenda for today. So quick housekeeping and thank you. Those of you who are new to Zoom, on your main screen you have the view option on PC, top of screen. That's on if you're on a computer or on a desktop. The audio screen on PC is left hand side, depending on how you want to adjust the sound, and then raise hand icon if we need it. Just to validate things, if you can just raise hand, which is normally bottom of the screen in the middle. Submit question and answers, of course, via the Q&A tab. Please put your question in, any comment statement you'd like to. We'll ensure that we capture as much as we can in terms of your comment and question. If you want to leave the webinar, not because you're bored, but if for any personal reason, leave meeting is on the right hand side of the screen. If you're using a tablet or a phone, everything is on top of your screen. There will be lots of poll as well, just to make sure we gather as much rich answers from you to make the webinar interesting as well. So, Dr. Ganjan, thank you to all of you. Thank you for being here. Thank you to Reshma for giving back, and to all the speakers as well. We had a lot of speakers for the past 25 webinars. So thanks a million to everybody for giving back in this difficult time. Of course, you'll have a CPD as well as a certificate of attendance. Please email me at anil@cpdtalk.com. Please email me after the event if possible, and we'll get you your certificate of attendance. So please send me an email as well. So who I am then quickly, I love construction, love learning, love sharing, love people, 18 years in the construction industry, and I'm extremely passionate about giving back as well, and hence the reason why we're here today. So I want to start with a menti.com, just to really, for Reshma to really get some interest on where you are in terms of the context of arbitration internationally. So I'm going to share this with you. Just bear with us as we get into menti.com. So, right, okay, and so if you can just type in menti.com, menti.com, and also already some of you have already done it. So, and then type in 748905 to log in. So we can see South Africa already, a colleague from South Africa. So basically type in www.menti.com using the code 748905 to gauge where you are. So already we can see the screen, and you can see the screen as well. Already we have people from Nigeria, India, Mauritius, Singapore, Sierra Leone. Thank you for being here. Rwanda, Oman, thank you again. Someone has put hi. I don't know if that's a country, but never mind. Canada, Ghana. So we've captured mostly all the continent right now. Thank you for being again. Yeah, please put in, again, if you're in Mauritius, it could be any villages, you are, any district you are, definitely put in as well. So it just shows you how interactive this is. So we've got Mayberg, maybe Gervais is from there as well. So UAE, again, so already we can see love Mauritius, yeah. So already I can see lots of you logging in as well. So we've got a bit of everywhere today. So thank you for being here. Lots of you, and also from Africa as well, Zambia, Rwanda, Sierra Leone, Nigeria, India as well. So lots of you are from Mauritius, India, and Nigeria, as well as UAE and Conakry, Guinea. This is Vince. So thank you for being here as we move on. So please put in, and Qatar, I can see a colleague from Qatar as well. So thank you for being here, everybody, as I stop sharing. and then move on to the slides. Okay, so first slide, thank you very much. And I just want to share a recent survey which I shared when I was with Mark Watson a few weeks ago on his presentation. And the main dispute in the past 12 months, a magazine which I found out in Building Magazine, is that extension of time is one of the biggest issue currently in the industry, followed from valuation of final account, valuation of variation, loss expense on the full position, defective work, failure to comply with provision. So as you can see there's lots of key items. The big five, I'll say, is extension of time being one of the litigious claimable issue. We've got valuation of final account, valuation of variation, loss and expense, and defective work. So I want to show you a video before we formally introduce Reshma. So just bear with us as I show you the video before we kick off. And it's an honor to have someone representing the Chartered Institute of Arbitrators today. And I'm sure we will be most of us will be inspired to join the FCIArb. So let me just show you this video as we kick off with our webinar. So here we go, just bear with us. And if you can hear the sound and the screen as well, please put your hands up as well, just for me to understand that everything's fine as well. Okay, off we go. And then I'm just gonna now play the video. Okay.
The best thing about being a member of FCIArb is being part of a community of ADR practitioners where one gains access to professional development opportunities through seminars, workshops, and accreditation courses, as well as access to networking opportunities through conferences and social events.
We offer a range of courses which equip people with the knowledge and skills that they need to to avoid, manage, and resolve a dispute, because we believe these are fundamentally important skills for people to learn.
The courses that I've taken through the Chartered Institute of Arbitrators have all been led by very senior practitioners. So also as a senior practitioner, it gives me an awful lot of opportunity to learn more, much more than sitting in a classroom and listening to someone speak.
Well, I'd recommend the FCIArb training because it's very thorough. It's recognised as a gold standard, and so having the qualifications will help you in your career.
First of all, one of the benefits of being an associate at Chartered Institute of Arbitrators is an opportunity to visit events and conferences on highly interesting topics. You're not only engaged in discussions, but also you receive plenty of networking opportunities.
Not only was I able to attend events with leading practitioners and scholars in the field of international arbitration, but also FCIArb allowed me to meet other students from all over the world with similar interests, and thus develop further networking and professional skills.
Okay, so as we can see, thank you again if you've seen the video. Very inspiring, of course, and you want to be part of a global professional network that sets the standard in promoting a harmonious society, in helping people and organizations avoid, manage, and resolve conflict. So thank you for watching that video as we move on. So we're going to start a quick survey just before we kick off the presentation as well. So right, let me just do the survey quickly, and allow panelists to vote as well, and here we go. So if you can see the survey here, and that's the future really, and the panelists can vote. How many of you would like to become an arbitrator? It's a quite direct question, but of course we'll find out, of course, once Reshma enlightens us. So if you can just please put a yes or a no, how many of you would like to become an arbitrator? I know there's lots of interest in that. So again, if you can please give us a vote on that. So it's a yes or a no answer. Can't say anything yet. Okay. Okay, I still can't see anybody voting. So let me just see if Damsen, can you and Reshma, can you vote? Okay, no poll appearing. 1 minute, and then I'm just going to share that again. Relaunch polling. Here we go. Right. Can you see the poll now? Yes, I think we can. Or now viewing. So how many of you would like to become an arbitrator? Right, I think we are having a small issue with that, no problem. Okay, so never mind, we will get back to the poll shortly. I'm just going to end this poll for now. Okay, so here we go. And let me introduce you to Reshma as we move on. So here we go, 1 sec. Okay, so I want to just have the presenter before we kickstart. We had a small issue with the survey, but I'll check that out shortly. So just to present Reshma Oogorah, FCIArb, practices as a legal counsel and arbitrator. She's a dual qualified lawyer, admitted to practice law in Mauritius and in England and Wales. She's also a fellow of the Chartered Institute of Arbitrators. Reshma recently founded Niyom Legal, a legal consultancy firm where she focuses on construction and commercial arbitration matters. She assists businesses based in or interested in doing business in the Middle East and Africa, including Mauritius. Reshma has been involved in high-value complex arbitration and litigation in Mauritius, the Middle East, and the UK, many of which were construction disputes. She has previously worked as a construction and arbitration associate at various law firms in the Middle East, where she advised on and resolved disputes related to some of the largest construction projects in the world, such as the construction of World Cup stadiums, infrastructure projects, hotel, gated communities, and theme park, amongst others. She has also been involved in ad hoc arbitration, as well as arbitration in the various institutional roles, such as the ICC, DIFC, HKIC, DIC, QICCA, and ADCCAC. Rules have in various jurisdictions, including Mauritius, England, Wales, UAE, Qatar, Bahrain, Kuwait, and Oman. So please join me in welcoming Reshma, and please put your hands up as well for welcoming Reshma today. So Reshma, if you can just put your video on, please, as well as get your slide over. So here we go, and then I'm just going to stop sharing on my side as Reshma started putting the video on. So if you can put your slides on, Reshma,
yeah,
and we can kick off the presentation.
Thank you very much for that lovely introduction, Anil.
Yeah.
And thank you again, everyone, for being here today.
Okay, so we can see your slide as well. And again, everybody, if you can see my slide, please put your hands up as well. And yeah, and we can see everything. So thank you very much indeed. And take it away, Reshma, all yours. And thank you very much indeed for being here.
Thank you. Thank you very much, Anil. Well, I wanted to say thank you again, everyone, for being here with me today. I know that quite a few of you are probably celebrating the Eid this weekend, and Eid Mubarak to those of you who are celebrating. We really appreciate that you've chosen to be with us in this presentation this morning. So we're here today to talk about arbitration in the context of the construction industry. Before we dive in, I'll just go over the agenda for today. So today's presentation will be in 3 parts. In the first part, I'll be clarifying what arbitration is, and we'll also be touching on the characteristics and pros and cons of arbitration. In the second part, I'll be talking about the relevance of arbitration to the construction industry. So in other words, we'll be ascertaining together whether arbitration is appropriate for construction projects or construction contracts. I'll also be speaking about how you can incorporate arbitration in your construction contracts. And then finally, in the third part, we'll be going over a flow chart which shows the main steps involved in a typical construction arbitration. And then most importantly, we'll be discussing the role of construction professionals in a construction arbitration, followed by a Q&A session where I'll be responding to any questions you may have. Okay, sure. Right, so let's dive straight in. What is arbitration? Well, first of all, arbitration is a form of dispute resolution. There are actually a number of different ways to resolve a contractual dispute or a construction dispute. For example, disputes may be resolved through negotiation, through mediation, adjudication, and so on. And the most obvious or common way to finally resolve a dispute when amicable methods do not work is through the courts. Therefore, the courts is the default dispute resolution mechanism applicable in any contract. Arbitration is an alternative to court, which means that the parties to a contract can choose to have their disputes resolved through arbitration instead of the courts. Now, I'm going to assume that most of you have a very basic understanding of what the court is and how the court works. And during the course of this presentation today, I'll be contrasting the attributes of arbitration to the attributes of the court, and hopefully that will help you understand the concept better. Right, so as well as being a form of dispute resolution, arbitration is a private form of dispute resolution. The proceedings of an arbitration is usually heard in private, that is behind closed doors, compared to court proceedings, which are usually conducted in public. In an arbitration, usually only certain specific persons who are involved in the disputes may have access to documents relevant to the dispute and can attend the hearing. In contrast to that, anyone, irrespective of whether they are involved in a court dispute, can usually attend a court hearing. So far, we've learned that arbitration is a form of dispute resolution, and also that it is a private form of dispute resolution. What else? So in addition to being a private form of dispute resolution, arbitration is a contractual form of dispute resolution. And this means that it is a creation of contract. Parties deliberately choose to use arbitration as a final and binding alternative method for resolving any dispute instead of court, which, as we just saw, is the default mechanism for resolving a dispute. Now, the parties to a contract can agree to choose arbitration over court at any time. It usually happens at the time of entering into the contract, but it can also happen anytime afterwards, and they can even agree to do so at the time of the dispute instead of going to court. So arbitration provides for the determination of disputes by a third-party arbitrator or arbitration panel. In court, as you know, a judge or a panel of judges will decide on a dispute, and the court will usually issue a court judgment to communicate its decision on a case. In arbitration, an arbitrator or a panel of arbitrators perform the function of the judge. So instead also of a judgment, the arbitrator or arbitrators will issue an arbitral award or just an award in which they will convey the decision as well as the reasons for the decision. So to recap here, and I'm repeating because we're going to get into technical stuff later, so I want to make sure that you have a clear understanding of the definition. So to recap, arbitration is a private contractual form of dispute resolution. It provides for the determination of disputes by a third-party arbitrator selected by the parties to the dispute. So in court, parties are allocated a judge or a panel of judges, and they have no control over who decides the dispute. In contrast, in arbitration, when a dispute arises, depending on the type of arbitration or the terms of the arbitration agreement, the parties choose the arbitrator who will decide their dispute. There are actually a few ways in which this can be done, and amongst them, for example, is if there's going to be only one arbitrator, the parties may mutually agree on the arbitrator who will decide the dispute. If there's going to be 3 arbitrators in an arbitration, each party may nominate one arbitrator, and then the 2 arbitrators who've been nominated by the parties may then nominate the 3rd arbitrator. And we would normally refer to this 3rd arbitrator as the chair or the president of the tribunal. And thirdly, parties may also designate a specific mechanism in their contract to nominate or appoint their arbitrators through a third party. So for example, in institutional arbitrations, we will see in a moment what these are, but in institutional arbitrations, parties commit to a predefined mechanism for the nomination and appointment of arbitrators through an institution. Now, the arbitration process and the court process are very similar in the sense that disputes are resolved on the basis of material facts, documents, and relevant principles of law. So in both court and arbitration, the decision makers have to consider the facts of the dispute, the documents, which is the evidence, and this also includes any witness evidence. And they also have to apply the law when they make their decision. I would like to highlight here that both the decision of the court and the decision resulting from an arbitration are final and binding. And in the court process, there's a system of appeal where the decision of a lower court can be appealed to a higher court. Usually there's a 3-tiered court process or a 2-tiered appeal process, whereas in arbitration, there are no or very limited appeal rights. And a party can only challenge the decision of the arbitral tribunal on limited grounds, for example, on public policy grounds or a failure to apply the law correctly. So let us read this definition again together one last time before we move on.
Yeah.
And by the way, this definition is from a website called designbuildings.co.uk, which is a platform where construction professionals share their knowledge of construction. There's actually a short article there on arbitration in the construction industry, if ever you're interested in reading more about this and generally about construction and construction matters. So arbitration is a private contractual form of dispute resolution. It provides for the determination of disputes by a third-party arbitrator or arbitration panel selected by the parties to the dispute. Disputes are resolved on the basis of material facts, documents, and relevant principles of law. So now that we understand what arbitration is, let's look at the type of arbitrations. There are actually two main types of arbitration. There's ad hoc arbitration and institutional arbitration. In ad hoc arbitration, the parties decide on the rules of procedure themselves, and if they are unable to agree, prior to the appointment of any arbitrators, the court would intervene to resolve any such disagreement. So for example, in an ad hoc arbitration, the parties would normally mutually agree on how to appoint the arbitrators, where to hold the arbitration, or what language to use in the arbitration. And if they're unable to agree on such matters, they will refer these to the local court, which will decide on these matters for them. In contrast to that, in an institutional arbitration, the dispute is administered by an institution, which has what we call rules of arbitration. And those rules describe the procedure to be adopted by the parties in making decisions related to their arbitration. Generally, these institutions also have a private court attached to them, to which they can turn to make any decisions prior to the appointment of arbitrators or any issue which arbitrators do not have the authority to decide. Now, there are many such arbitration institutions around the world. There's the ICC, for example, which is an international arbitration institution, and it's the arbitration arm to the International Chamber of Commerce, which is headquartered in Paris. They have branches and representative offices all around the world, for example, in Singapore, in Hong Kong, in the United Arab Emirates, where I am right now. And locally, in several countries, there are also arbitral institutions. In Mauritius, we have two that I know of. There's the MIAC, the Mauritius International Arbitration Center. And then there's also the MARC, which is the Alternative Dispute Resolution arm of the Mauritius Chamber of Commerce and Industry. In the United Arab Emirates, there are several arbitral institutions across the 7 Emirates. In Dubai, we've got the Dubai International Financial Center and the LCIA, the London Court of International Arbitration. So we call it the DIC LCIA. It is an institution set up jointly by these two the court and these two institutions.
Yeah.
We've also got the Dubai International Arbitration Center, which we refer to as the DIAC, in mainland Dubai. Now, Anil, you mentioned the survey before, and this survey, a survey was actually recently conducted by the Queen Mary University in London and Vincent Masons, which is an international law firm. And this survey was actually on international arbitration, which was aimed at driving efficiency in international construction disputes. Some very interesting findings emerged from that survey, and we'll be covering quite a few of them during the course of this presentation today, and hopefully the polls will work, because we also want to put some of those questions to you all. So this is a quote from that survey. And I'm going to read from that quote. The most frequently used institution in the respondents' experience was the ICC at 71%, followed by the LCIA, 32%. Ad hoc arbitration was used in nearly a third of arbitrations. So interestingly, in the respondents' experience, the ICC was the institution which was most frequently used for resolving international construction disputes. And ad hoc arbitration was used in nearly a third of all arbitrations where respondents are involved, which means that 2/3 of the arbitrations where the respondents were involved were institutional arbitration. So now that we have an understanding of what arbitration is and the two types of arbitration, let us look at the advantages and disadvantages of arbitration. So what are the pros and cons of arbitration when compared to court? As we discussed before, court is the default mechanism for resolving a contractual or construction dispute, whereas arbitration is consensual, and this is why we've got this contrast between consensual and default. In arbitration, parties expressly choose to arbitrate their dispute instead of going to court. And as we saw before, they normally do that when they conclude their contracts, but they can also do that at a later stage. Private versus public. We also saw earlier that arbitration is conducted privately behind closed doors, and this can be at a venue dedicated to conducting arbitration hearings. It can also be conducted privately at a hotel or at another suitable venue agreed by the parties. The documents of the dispute and the hearing are kept private. In contrast to that, court proceedings are generally conducted in public. Anyone can attend the hearing and can have access to the documents submitted to the court, which are of public record. Choice of arbitrators versus allocation of judges. Now, in arbitration, the parties pick the decision makers to their dispute. That is, the arbitrators, and they can pick someone they trust irrespective of whether they are legally qualified. Usually parties would pick someone who has a reputation of being neutral and fair, and also who would have a good understanding of the subject matter of the dispute. And they're also free to choose such professionals from a pool of widely available arbitrators worldwide who have specific experience in the subject matter of the dispute. At court, the parties are allocated a judge or a panel of judges, and they do not really have much choice. They have to accept the judges who are allocated to their dispute from the limited number of judges who are retained by the judiciary of the country in question. Flexibility versus rigidity. Well, in an arbitration, the process is guided by the parties' choice and their arbitration agreement. And in these arbitration agreements, they select the rules that will govern their arbitration. Usually those rules are quite flexible and contain a lot of gaps, and the parties and the arbitrators have the opportunity to further decide on how the arbitration should be conducted. So for example, they can decide when to submit their pleadings, whether or not to have a hearing, whether or not to have a document production phase, whether or not to have experts, etc. Arbitration is also conducted in a more relaxed and cool environment with less strict decorum compared to court. So for example, there are lesser formalities in an arbitration. Lawyers and arbitrators do not wear a court robe. No gavel is used in an arbitration setting. And In contrast to that, in court, the process is guided by the framework established by the court procedure, which is usually quite rigid and strict. And although, these days we are seeing the emergence of new court systems which are adopting a more flexible approach, such as the Dubai International Financial Center Court, which we refer to as the DIFC Court, and the Abu Dhabi Global Market Courts, which we refer to as the ADGM courts. And in my view, these types of courts are in a good position to offer certain advantages, some of the advantages of arbitration. And hopefully Mauritius will consider having such a court soon. Right, so speed versus delays. Generally, it takes less time for a case to run its course through an arbitration process compared to a court process. A court process, as we discussed earlier, goes through at least 2 levels of appeal. And I'm told that it takes between 5 to 10 years for a case to run its course through the courts. And in contrast to that, since the parties have control over the arbitral process, and in the case of institutional arbitration, the arbitration is monitored by an institution which focuses on efficiency, a typical arbitration is completed within a year to 2.5, 3 years. And with certain institutions, it is also possible to opt for expedited arbitration proceedings when arbitration must be completed within 6 months. What else? So limited to no appeal rights versus appeal rights. We've already discussed that, so I won't go into detail, except to say that the decision of an arbitrator is final and binding. It may only be challenged on limited grounds. And with court, as we discussed, parties may contest the decision on at least 2 appeal levels. Well, cost of arbitration, I know that this is a concern for many. International arbitration can be less expensive than court litigation, as it takes less time and achieves certain procedural efficiencies not achievable through the local courts. And there's always an opportunity cost to time wasted through the courts. You know, you want to be doing business and you don't want to be engaging your resources in the court process. And as we saw, the court process takes a very long time. However, as arbitration is becoming more and more popular, there's a perception that it is also becoming more expensive. And this is why we are increasingly seeing this concern being addressed by certain institutions like the Chartered Institute of Arbitrators, which rolled out a service called the Business Arbitration Scheme, or the BAS scheme, to cater for disputes of lower value and charges a fixed cost for arbitrating such disputes. There's also other new emerging institutions such as the LOS that I know of, whose goal is, amongst others, to be more cost efficient. Now, one of the attributes of arbitration is technical expertise, so I'd like to add a few points there. When choosing their arbitrators, parties may pick someone who's technically qualified in a field which forms part of the subject matter of the dispute. So for example, in a construction arbitration with complex technical issues such as delay, destruction, or structural defects, parties may decide that their arbitral tribunals should constitute not only of legal professionals, but also of construction professionals, such as a project manager or a civil engineer who can really add value to the panel. There's also an increasing number of professionals in the construction industry who are both technically and legally qualified to arbitrate construction disputes. And because of this growing trend, universities and professional institutions around the world now cater to these specific professionals by providing specific master's degrees or LLMs in construction law and arbitration. And there's also professional organizations which support construction professionals who would like to gain the necessary skills to position themselves as arbitrator for construction disputes. And some of these institutions are, for example, the FCIArb, which we just discussed, and also the RICS, which are both headquartered in London with branches all over the world. And they also provide courses all over the world. Now, to conclude on this part, on what is arbitration and what are its characteristics, let's view this video from the FCIArb together. So Anil, I'll hand over to you so that you can play this video. You're on mute, Anil, we cannot hear you.
Yeah, sorry. So yeah, I'm just going to share this video. Thank you, Reshma. Just bear with us, everybody, as I try to get the video out. So I'm going to share this with you now, and then I'll share the screen. So I'm going to take your screen away, Reshma. Thank you for part one, of course. As we get into, can you see my screen, Reshma?
Yes.
Okay, so I'm just going to play the video now, making sure we've got the sound and everything else, and off we go. So making sure we've got the sound as well, and thank you for that.
FCIArb enables professionals to develop their career to chartered arbitrator status. We offer training in international and domestic arbitration and offer rigorous teaching and assessment standards. An arbitrator can act as a sole decision maker or as part of an arbitration panel to decide between parties in a dispute by making an award based on the evidence presented. You can train either in the UK or in any of the CIR branches where training is offered. These include Asia, Africa, Australia, Europe, and North America. For candidates with absolutely no experience of arbitration, you can start our training with an introduction course. We also offer courses for candidates with a law degree and some experience in arbitration. The training for candidates with no experience in arbitration starts with an introduction course and is followed by modules that cover the law of arbitration, the law of obligations on civil evidence, and how to write an award. Candidates with a law degree or some experience can take accelerated route courses, which are assessment-only courses testing their knowledge of the subject. You can sign up online on our website at the training section of www.ciarb.org or contact the Education and Training team for further instructions.
Okay, so if you can just, Reshma, if you can, let's take some questions now. We've got lots of questions coming in, and this is where we will need, so just bear with me. So don't share your screen yet, and I'm going to take some questions from you, Reshma.
Yeah, sure.
Okay, so Reshma, the first question is from Akshay. Can you hear me, Reshma?
Yes, I can.
So Akshay from New Zealand, what could be the future of dispute resolution? Is the Middle East in process to integrate digital technologies to tackle future dispute resolution? So how do you see the future of dispute resolution when it comes to technological advancement?
Well, we're seeing a lot of technological advancement, and obviously this has been accelerated through what we're going through right now in the world with the COVID-19 situation. And a lot of disputes have actually been heard virtually over the course of these 3 to 4 months. And there are different platforms that are being used. The platforms that are being used, for example, Zoom, there's also other platforms, and many other platforms are being developed. Some law firms and legal technological companies which are in legal technology have already rolled out certain platforms to hear arbitration hearings online and virtually. So there's also a lot of advocacy going on for green arbitrations, because arbitration can be quite costly with arbitrators and parties having to travel. That adds up to the cost with accommodation costs, traveling costs, etc. And obviously that's not very good for an environment. So along with what's going on with COVID-19 and the push for to be more ecological in our approach to everything, there is definitely a big push going on so that arbitration can be held online.
Yeah, and just quick one as well at the back of the question, we've seen in COVID-19 regarding people who are actually doing hearing online. Is that right? I mean, have you experienced it yourself, and do you see a way forward as opposed to the physical connection?
Well, there's pros and cons to everything. The good thing is that we can carry on with arbitrations. We don't have to wait if parties agree to do them online. And this is the key thing. Parties have to agree to have the arbitration heard online. And in my experience and knowledge, arbitrators or the tribunal wouldn't agree to having an arbitration held online if the parties do not agree. So it's really, the choice of the parties whether to have it online or not.
Okay.
Whether it works or it doesn't, that's a different question. I think it would depend on the type of arbitration. There are surely concerns about, witnesses having other people in the room when they are giving evidence and such things. But there's a lot of talk surrounding how that could be addressed. For example, we're talking about 360-degree cameras, etc. And with regards to the human connection, Anil, yes, doing a webinar and doing a seminar are two different things, but adapting, we're great at adapting to new ways. I mean, I cannot wait to meet you and meet people in person. That's definitely the better option.
Yeah.
But
okay.
We have to adapt. We have to adapt to.
But so did you say, there was one thing you said, like everybody need to agree to do the online. If one doesn't agree, you can't do it.
Yeah, generally that's how it works, unless it's already in the contract. So what we can do, and sometimes I'm doing that in contracts right now with some clients and certain types of not necessarily consortium contracts though, but more simple contracts where we're inserting specific clauses to say that the arbitration can be conducted online.
Okay. Fantastic.
So in that case, that would be pre-agreed, and the parties would have to conduct the arbitration online if ever there's a difficulty in conducting it in person.
All right, thank you very much indeed. We've got about 10 minutes to take more questions, as there's already 23 questions here. There's one from V. Punier. In construction contract, we have consultant to supervise and ensure contractual obligation are met between the client and contractor. The consultant is already arbitrating on behalf of both the client and the construction. So I'm not too sure what was the question there. There's a question from Henry from Nigeria. This is directly related to you, Reshma. Must one be a lawyer to become an arbitrator?
Well, the short answer to that is no. You don't have to be a lawyer to be an arbitrator, but arbitrators are expected to know and understand the law because one of their main roles is to apply the law.
Okay.
So it would be very helpful, and it would definitely help. It would help you, and it would also, be appropriate if you have legal qualifications alongside your other qualifications.
Okay.
But you don't have to be a practicing lawyer to be an arbitrator.
All right. Thank you very much indeed. We've got a question from Maggie G. What would happen if arbitration proceeding fail in solving contractual dispute? So what happens if arbitration fails?
I'm not sure what you mean by arbitration fails, because an arbitration actually produces a binding decision. So the arbitration is going to decide whether a party wins or loses. It's similar to a court situation. So,
okay.
So I would take that to mean that if the decision is not in favor of a party, what are that party's options? And yes, so as we discussed earlier, arbitration is a final binding form of dispute resolution, and decisions of arbitral tribunals cannot be appealed. I mean, they can be appealed, but on very limited grounds. So that's one of the things that they could be doing. They could scrutinize the arbitral award to see if there's anything there that they could challenge.
Okay. Thank you, Reshma. There's a very interesting question coming up from Saibu. Good morning. Please, what is the minimum and maximum number of arbitrators that constitute a panel?
Okay, the minimum number is 1. We should always have odd numbers of arbitrators because we need to have a chair. We can't have a tie if there's an even number. There can be any odd number of arbitrators, and to be honest, I have never encountered an arbitral tribunal with more than 3 arbitrators, but it is possible to have a higher number of arbitrators. I'm not sure how practical that would be, but it is.
Okay, there's one from Logan. You said the decision of the arbitration judgment can't be overruled easily. We have a case in Mauritius whereby the Mauritian government and Betamax in 2015 from what I know, Betamax won in arbitration in Singapore, but the Mauritian Supreme Court overruled that. So just your views on that. What's your thoughts?
So what we said was that there are limited or no appeal rights in arbitration, but you know, there's always exceptions, and they can be set aside.
Okay, thank you very much indeed. The next question is, are court rules for arbitration same across the world or different? So do they have the same principle, or do they, you know, do they kind of, it depends on the cultural sensitivity? What's your thought on that one?
Well, court rules do not apply to arbitration because arbitration has separate rules generally. I mean, there are exceptions to that as well in countries where the procedural law is mandatory. Yes, so rules vary across the world. There are arbitration laws in different countries and they differ, but there is what we call the UNCITRAL model law, and many countries across the world have adopted that law, and therefore insofar as countries have adopted that model law, they are very similar, but there are derogations to that as well. So yeah, it's very important to check the rules in different countries if you're going to use the procedural laws of a country.
Thank you very much indeed, Reshma. We've got one from Jivesh, very important as well. Jivesh is a lawyer too. Does the arbitrator have immunity?
Well, that's a very
that sounds like God to me.
Controversial question. Well, it would depend. It would depend whether they have immunity, and in my view, not entirely. No.
Okay. Okay. So it's a good question. Thank you very much indeed. We've got a question from. Has there been any beings from Africa? Has there from Conakry, Guinea? Has there been any cases where one party challenged the final decision of the arbitrator or a panel of arbitrators? So have you been in cases where there has been a decision? I'm sure there has, but what's your experience?
Yes, yes, it happens. You know, there's always challenges of arbitrators. You know, that's one of the guerrilla tactics that's adopted in certain arbitrations when parties do not really want to move the dispute. And obviously sometimes, you know, there are very strong and valid grounds to challenge the appointment of arbitrators.
As you know, in this platform today, we have lots of people, lots of young engineers, lots of graduates, lots of senior practitioners and directors. One quick, nice question from Kurt. What is the difference between arbitration and litigation? If you can just clear that rule for us.
Yeah, so litigation, okay, interesting. Well, litigation, when we talk about litigation, we usually referring to court, to the court process, and this is what we would term as litigation. And the term for the alternative to court is arbitration. So litigation and court would be similar, I would say, and arbitration is you know, the alternative.
Okay, one question from Ashvin. When the arbitration award is released by tribunal, then is it necessary to get approved by the court? Exclamation mark.
No, it's not necessary to be approved by the court, but there's if the other side pays, you know, if the losing party pays, there's no need to even go through to the court. But in some cases, you know, the losing party do not voluntarily pay, and then, you know, you have to go through a court process in order to enforce that arbitral award, and that's when you may need to have it authenticated and legalized or approved by a court.
Awesome, thank you very much indeed. I'll get two more questions before we move for two of your presentation. We have John McGowan. What are relative benefits of international court versus arbitration in Mauritius, assuming Mauritius introduces international court? So what are the relative benefits of an international court versus an arbitration?
Well, we don't really have an international court in Mauritius. We have, I mean, that's also debatable because we have in Mauritius we have the Supreme Court, and then we've got the Judicial Committee of the Privy Council as the highest court in the court system. What's the difference? I think the difference would be similar to what we discuss as being the attributes and characteristics, unless Mauritius were to set up a new type of court, like I mentioned before, like the DFCA ADGM, where there would be the advantages of some of the advantages of arbitration attached to it.
Okay, thank you very much indeed. And then we'll take one more question. Obviously, we've got lots of questions coming in, Reshma. We could end up here in the next 8 hours answering those questions, but we'll answer as much as we can. But one more question before we move on to part 2 is that if I'm just a normal engineer or a QS or an architect or a project manager, what is the pathway to arbitration? Do we just follow a RICS course? Do we join FCIArb? What's the next stage? Just briefly on your experience.
Yeah, there are many different ways. You know, people end up in professions or, you know, in a specific role by adopting different ways. But increasingly, we're seeing construction professionals qualifying for the FCIArb or the RICS. And from what I know, the RICS and the FCIArb have a, they recognize each other's qualifications. So, for example, if you were to do the diploma in dispute resolution for the RICS, the Chartered Institute of Arbitrators would approve that, and alongside getting the accreditation from the RICS, you could also get the FCIArb's accreditation by doing a peer interview. So definitely going through the these professional institutions would be an option. The other option would be to do an LLM. You know, professionals in other industries can opt to do a master's degree in construction law or construction and law, or an LLM in, you know, the specific area that they want to practice in.
Yeah.
And why would you choose one over the other also is, you know, it would depend. From what I know, if you have a professional qualification, it's difficult to then proceed with academia. Because academic institutions usually want you to have a master's degree before you do a PhD. So that's probably something to bear in mind. If you wanted to continue in academia, then it's better for you to go through an academic institution as opposed to a professional institution. Okay. But if your goal is to remain a professional, you have no interest whatsoever in academia, then, you know, the professional qualifications should be enough.
Okay, thank you very much. We'll take one more before we get on to you. This is probably from a contractor or a consultant. Is it mandatory to include provision and arbitration even for small value contract? So if a contract is 6 months, can you allow arbitration, or what would your advice be? I know you would say it depends, but would it be worth it to have an arbitration in a 6-month contract?
Yeah, well, we are going to see about when arbitration is appropriate in construction projects in a moment. So maybe your answer will be answered better then. But the short response to that would be, yes, it depends. And it's not so much about the timing of the contract, but more about the value and the complexity of the contract in question. So usually the higher the value, the more appropriate arbitration is. The higher the complexity, the more appropriate arbitration is, and vice versa.
Okay, thank you very much indeed. We move on to part 2, Reshma. I'm also thanking everybody. I've just got a message from WhatsApp. People actually listening us from the car. So they are actually in the car listening to you, Reshma. So thank you for this as well.
I feel really honored.
Yeah, so thank you for whoever sent me the WhatsApp. I can't mention the name yet, but thank you for watching us in your car as we move on to part 2. So if you can share your screen, Reshma, I know you're having, and then back on to part 2. We will also try the survey as well. Let me just try if the survey is working.
Okay.
If you could, I don't know if this is working. Can you see it now? No, so again, I think we are having problem with the Zoom issue today, but I will try to sort that out during the presentation. Off you go for part 2, Reshma. thank you very much indeed for part one and for enlightening us as we move on to part two of your presentation.
Okay, so in part two, we'll be talking about arbitration and the construction industry. And yes, so one of the questions that was raised, I think, was, is arbitration appropriate for construction disputes? And when is arbitration appropriate for construction disputes? And you guessed it right. The answer is it depends. And that's because not all construction projects are created equal. Some are low value, so some are of low value, some are of high value, some are simple, some are complex, some have local parties involved, some have international parties involved. So where do we start when deciding if arbitration would be appropriate for a particular construction project or a construction contract? Well, in my view, okay, first of all, it's important to note that the decision of whether to arbitrate a construction dispute or allow the default mechanism of submitting a dispute to court to prevail is usually made at the contractual stage, okay? And that's at a time when the parties are usually happy to conclude a deal and they are not really thinking of disputes or the dispute resolution clause. You know, that's probably just an afterthought at that point in time. Yeah. However, now that you know about this, it's important that you consider the dispute resolution clause at that point itself, at the point of concluding a contract. And that's because when parties are in dispute, it becomes difficult for them to agree on anything, let alone how to resolve their disputes. Now, let's assume that you are about to conclude a contract for a construction project. How do you decide whether to pick court or arbitration for the resolution of your disputes? Well, there are many factors to consider, and a starting point would be to consider the pros and cons of arbitration versus court, which we discussed in detail already. I won't be repeating them here, but for your benefit, I will just raise a few relevant questions which you should be asking yourselves when making your decision in respect of each of the characteristics listed here. So the first one is consensual versus default. The relevant questions are you a local player in the market or an international organization? Do you trust the local court system enough to have your dispute resolved through the court process, or would you like to avoid the court process altogether? Secondly, private versus public. Are there any advantages to having your dispute kept confidential? Would having a dispute in court negatively affect the reputation of your organization? Thirdly, choice of arbitrators versus allocation of judges. Are you happy with the competence and experience of the judges in your local courts? Or would you like to be able to choose the decision makers for your dispute from a pool of local and international legal and construction professionals? Are there any benefits to picking decision makers with a technical construction background? Fourthly, flexibility versus rigidity. Would you like to have a higher degree of control over the disputes process in an arbitration? Or are you okay with the rigidity of the procedure associated with the court process? Limited or no appeal rights versus appeal rights. Is there a need to have the disputes in your project resolved quickly so that you may continue to complete the works? Or would you like to have a decision within 12 to 3 months? I mean, would you like to have a decision within 12 months to 3 years? Yeah. Or can you wait 5 years to 10 years? So that was for speed and rigidity, speed and delays. And finally, would you like to have a final and binding decision in just one arbitral process, or would you prefer to have the option of appealing the first decision received from a court? There's also a couple of other factors to consider, I think, and those are the value of the project. Like I mentioned before, usually the lower the cost of the project, the less appropriate arbitration will be, and the higher the cost of the project, the more appropriate arbitration will be. Another factor to consider is complexity, and this is an extract from the survey, which from the Queen Mary University and Vincent Mason survey, which refers to complexity. And I'm going to read what it says here. It says that the 5 most defining features of international construction arbitration identified by respondents were the factual and technical complexity, 73%, the large amount of evidence involved, multiple claims and or multiple parties, large amounts in dispute, and the range of related issues. So when it comes to complexity, we do not only mean the technical complexity of the project itself, but we're also referring to the complexity of the transaction being contemplated. So for example, the construction deal may be complex if there are multiple parties involved, they come from different countries with different legal systems, there are multiple layers or stages to the contract, such as there's a procurement process, there are many different contractors, subcontractors, and suppliers involved, and so on. So yeah, so as we said, the more complex a project or the transaction, the more suitable arbitration will be.
Yeah, so if we, I think we will, if you move on to the pins and masons, in your view, which is the most common method of resolving construction dispute? We have arbitration, courts, mediation, and don't know. If you move on to the next questions. And then again, please have a look at that one. In your view, why do parties choose international construction arbitration over court litigation in resolving international construction dispute? We've got avoid the court, ability to select arbitrators, confidentiality and privacy, ability to select technical, non-legal arbitrators, and flexibility. And then the next poll as well. So the next poll is, what do you consider to be the minimum amount in dispute to be commercially sensible to pursue through international construction arbitration? These are less than USD 1 million, between 1 to 10 million, between 11 to 25 million, and between 25 to 50 million. So then, Reshma, if you just put on the pins and masons survey. So we had a similar responses. We were to try to do this. The free question I've just mentioned, I wanted to do that for Zoom, but obviously Zoom is not working. So we just move on to the next slide, please, Reshma. Where, regarding the responses by Pins and Mason and Queen Mary University of London, this is what it says. In the last 5 years, which dispute resolution procedures have you had experience with in the context of international construction dispute? And there we've got the 5 key ones, the 5 main responses. The first one is international commercial arbitration with a whopping 70%. Secondly, we have domestic commercial arbitration with a percentage of about 39%. Negotiation followed up with mediation and litigation. So what's your views on that one, Reshma? Why international commercial arbitration is the highest?
Anil, yes. So as we can see, and this is, just let me remind you, in the context of international construction disputes. And we saw earlier that these types of disputes are characterized by a high degree of complexity. And generally, practitioners and construction organizations tend to want these disputes to go through arbitration, through international arbitration instead of the courts, because they feel that an arbitration would be a better forum because they are better equipped with technical and non-technical arbitrators, for example, and professionals. And also there's more flexibility and less rigidity compared to court. And so there's usually a high volume of documents in construction disputes. And it can be quite difficult to navigate that when dealing with the court system, where in arbitration there's more flexibility in the technology being used and the systems being used. And this is why I think that most of these respondents had the experience of resolving their international construction disputes through arbitration, whether international or domestic, compared to litigation.
Okay, just quick one. I can see, and many of the audience can see as well, the fourth one being mediation. Why mediation being the fourth when we talk about collaboration all the time, we talk about teamwork? Why is mediation on the fourth on that list there on the survey?
Yeah, so mediation is actually a more amicable way of resolving a dispute. And usually what happens in a mediation is there's a third party who is a mediator who comes and tries to resolve the disputes between the parties, by asking them relevant questions, trying to see where, they may agree. I think we can see from the survey here that around 30% of the respondents had experience of having international construction disputes resolved through mediation.
Yeah.
And because there's a growing trend for parties to engage in mediation prior to any sort of confrontational or binding final means of dispute resolution, such as court or arbitration.
Okay. All right. Thank you. If we move on to the next poll, please. Okay, so the next question was, in your experience in the last 5 years, why have parties chosen international construction arbitration over litigation or resolving international construction dispute? One or more responses. Again, you've got the 5 key responses there. It's avoiding legal system, national court being one of them, ability to select arbitrators, confidentiality and privacy, avoiding local political pressure and intimidation, and finally, enforceability of the award. So in your experience the last 5 years, why have parties chosen international construction arbitration or litigation is those 5 key reasons. So again, Reshma, if you can tell me as to why avoiding legal system, national court is one of the primary reasons as to why this is actually thriving here.
Yes, so this survey was done again for international construction disputes, and usually in those types of disputes there will be parties involved who are from different jurisdictions or different countries, and I think the perception might be that one party doesn't really want to go to the court of the other party if ever a dispute arises, and then they choose arbitration. They prefer to go for arbitration, which can be more neutral, or at least this is the perception that it's a more neutral, it can be more neutral method to resolve the disputes.
Okay, and interestingly, again, the audience looking at the screen right now, your second one where you mentioned ability to select arbitrators, does that give you a wider pool of having, unbiased arbitrators and more qualified? And this is where everybody can chip in as well, like maybe people from engineering background or QSing background as well?
Yeah, I mean, this is the amazing thing with arbitration, right? You can have arbitrators who are actually experienced in the subject matter of the dispute that you're dealing with. Yes, you do need arbitrators with legal, the legal aspect of the dispute is very, very important, obviously. And this is why we're increasingly seeing tribunals which are diverse and which constitute of both legal and construction professionals.
Okay.
And parties have the ability to choose arbitrators from a massive pool of such professionals around the world.
Okay, I can see costs at the end, costs being the last one, where I was thinking it could be the highest. Why is cost so cheap when it's looking at international arbitration? Could you just give us a bit of wisdom there?
Yes, I think when it comes to international construction disputes, they would generally be high-value projects. And even though we discussed that the cost of arbitration can be more than court, not always, it can be. It's actually not a consideration because the value of the project is so big that parties do not mind going for arbitration.
Okay, all right, thank you very much indeed. And then we move on to the next one. I believe we've got one last poll. We'll go to the survey before we move on to your presentation. So if an international construction dispute arose today, what is the minimum amount in dispute would you consider to be commercially sensible to pursue an international construction arbitration? So I will leave that one with you, Reshma, because I think you've got much more experience on that one. But I'm going to repeat that. So if there's a dispute today internationally, what is the minimum amount would you consider to be commercially sensible to pursue an international construction arbitration? So we could see there the highest being 1 to 10 million at 40%. What's your views generally on that one, Reshma?
Yes, so we can see from here that most of the respondents to this survey didn't think that it was worth going for international arbitration in disputes that are less than 1 million, but they are for going to arbitration for disputes which are more than 1 million. And we can see that because there's much higher percentages for the other answers combined. Okay, and yes, so basically we just discussed this. The cost of the arbitration has to be proportionate to the amount in dispute. You know, we can't go to arbitration and have to pay more for arbitrating versus what we're going to get out of the arbitration. It doesn't make commercial sense to do that.
Yeah.
This is why I think parties tend to feel that it's okay to arbitrate when the dispute is more than 1 million, but not less.
Okay, before you move on to your next slide, I wanted to ask you a question. So let me see if we can just, are you still on your part 2?
I am still on part 2, yes.
Okay, you're almost there. So let's do that, and then we'll take some more questions from the participants. We've got about 45 minutes to go on the webinar today.
Okay, so yes, so you know, as we saw, there was some very interesting questions and responses there. And just to give you the takeaway for today, and my view, basically. So in summary, construction arbitration, in my view, is appropriate for large value construction disputes, highly technical or complex projects, projects involving multiple stakeholders in different countries, and where confidentiality is needed to protect the interest of the business.
Reshma, just a quick one. Reshma, I do apologize. Just a quick one on large value construction dispute. So is it worth to be more than $2 million USD?
Yeah, so you see, everybody, I mean, people have different views on this. In my view, I think that anything less than, I'm not saying that anything less than 2 million is not worth considering for arbitration, because obviously it's not just about the value. There's also the other issues or, you know, potential matters that can arise, like technicality, complexity, confidentiality, etc. But usually I would put that figure to around 2 million.
Okay, thank you. Yeah.
And it's not appropriate for low value construction disputes. So in my view, less than $2 million. And it's also not appropriate where there's likely to be non-technical issues, and sometimes you can gauge that if you've worked with a certain contractor or you know, employer on other projects. You would know that they are quite good with structural and, you know, technical stuff, but maybe they don't pay on time, or you know, there's likely to be more non-technical issues involved in the dispute.
Yeah.
And also for simply structured projects, you know, if it's between two local parties, and it's just between two people, you know, that reduces the complexity of the dispute. Okay, so now we're moving on to the next part, which is how to include.
Reshma, we've got 10 minutes. Let's take some question and a breather for you as well. So let's take some question from the participant as we get some more question coming in. So if we take the question from, there's plenty of question, of course, but I'm just gonna try to. So can a contractor initiate an arbitration if the employer has decided to terminate the former contract? Just, I think it's a vague one, but can a contractor initiate arbitration if the employer has terminated the contract?
Well, it would depend. It would depend on whether you have an arbitration agreement in your construction contract. That's the first point. And then secondly, you would need to assess the merits of this arbitration. Is it worth going to arbitration? Do you have a good case? Do you have a not so good case? So, you know, it's a question of assessing the facts and your legal rights and obligations, really.
Okay. Another question is coming from, does arbitration decision takes as much time as court decision?
Well, again, it depends on the type of arbitration. You know, some, you know, I gave you the average earlier on. It can take between 5 to 10 years to go through the whole court process. And, you know, some lawyers back home in Mauritius have actually shared this with me. And yeah, it usually takes between anything between 6 months to 3 years in a typical arbitration. Now, there are arbitrations that can go beyond that, and there are court cases that can conclude within less time also.
Yeah.
So it depends.
Question from Mansoor. Can arbitration overrule local law?
It would depend on what type of law it is. So
Yeah.
in an arbitration, as we said, the arbitrators have to follow the law in making their decision. They have to follow all mandatory laws in making their decision. In some countries, they can do away with not applying the procedural laws because arbitration has its own set of procedural laws. I mean, they would have to apply the procedural laws of arbitration, but then that can be supplemented by arbitration rules, and those could have the, they can potentially override the local procedural.
Okay, thank you. Question from Sajjad from South Africa. Which route is more expensive, arbitration or litigation? This is also a good deciding factor. So based on your experience, which route do you think is more expensive and efficient, I guess?
Well, I generally work on a lot of arbitration matters, so I'm not, I don't really work on local litigation matters, especially in Mauritius. I know that the cost of going to litigation in Mauritius is probably cheaper than in other countries. Here, the courts that I have experience with are the DIFC court. And the price, the cost of arbitration in court can actually be on par when it comes to DIFC court and arbitration.
Okay. I think there's a fine line. So I think some of the questions have come on here. Could you just give us a few lines of what is the difference between arbitration and mediation?
Okay. Arbitration and mediation are actually very different. They are very, very different methods of dispute resolution. Mediation is more of mediation is not binding. First of all, mediation is not binding. The parties attempt mediation as a more amicable way of resolving the dispute, where they appoint a third party, a mediator, to come and help them resolve the dispute for them. Arbitration is like court, like we discussed before, and the parties appoint arbitrators who are going to be the decision makers, and their decision is actually binding on the parties. So if you don't have a satisfactory result with your mediation, you can move on, right? But with arbitration, it's conclusive. You have a decision from the arbitral tribunal, and that's final and binding and could only be challenged on limited grounds.
Wow, awesome. Thank you very much indeed for clearing that out for us. Who pays the fees involved in the arbitration process?
Yeah, so the parties pay the fees in the arbitration process, and usually the fees are split between the two parties involved in the arbitration.
Okay.
And fees are obviously recoverable by the winning party. There's this rule that says costs follow the event. So basically arbitration can be viewed as an investment. A party, knowing that it has a good case to arbitration in the hope that it will recover the money that's owed to it, etc. And in the hope also that it will recover its costs from this arbitration from the losing party.
A very important question coming through. Are there any prerequisites to be an expert witness in arbitration? So do you have to satisfy any condition before becoming a expert witness in an arbitration proceeding?
Yes, so we do actually look for certain specific attributes in an expert. We will be covering that later today, but just to answer the question, yes, we would be looking for a subject matter expert, so we would be looking for qualifications in a specific area. So for example, if we have an issue of delay, we would be looking for a delay expert with experience in those types of issues.
Awesome, thank you very much indeed. We've got a very important, I will take two more questions before we move on part 3. Suraj from India, we talk about AI, VR, virtual reality, artificial intelligence, and BIM can help in dispute resolution. I was actually reading an article yesterday about BIM helping out, with regard to arbitration. What's your views in that, in terms of innovative arbitration and dispute resolution coming of age?
I think it's high time that we have those types of things. In the legal industry, we tend to adopt technology quite, 10 years later. I remember recently I was watching, I was watching a webinar. My husband was here and he's more in technology, and he was like, oh my God, in my industry, we were talking about these things 10 years earlier, 10 years ago.
Wow. Yeah.
There's a lot of talks on, adopting technology and AI and, these types of, for example, we were talking about virtual platforms, etc. And I welcome that, actually.
Yeah.
I am happy that, we
Okay,
can,
awesome.
that help us achieve efficiency, both in terms of the dispute itself, the process, and also in terms of costs.
Fantastic. Thank you. There's a common question before we take on your part 3. Could you just give us, I know the talk is about arbitration, but what's the difference between arbitration and adjudication? Again, if you can just touch on that, please.
Yeah, adjudication is it can be similar and different, both. Again, adjudication is becoming more and more sophisticated now. There are a lot of laws surrounding adjudication, but traditionally, adjudication through a dispute adjudication board is carried out by certain experts, and traditionally dispute adjudication boards or adjudication is carried by technical experts who give their views on what the parties should do in case of a dispute before they move to arbitration. But right now, there's both binding and non-binding adjudication, and that's probably one of the differences between.
I've got a few more interesting questions as well for you, Reshma. So I want to get that over to you. Rahul, in India, in the Indian context where business relations in the construction industry are dominantly based on personal relation, do you think arbitration will gain momentum in the future, especially in Asia and Africa?
In countries like that, currently, this is the case for the Middle East as well. In most Asian countries where business are done on the basis of personal relationship and people want to preserve those relationships. Relationships can be preserved even if there's arbitration or court litigation, of course, but I think the push is more for mediation in that context, and that there is a big push for mediation.
So at the back of this, Reshma, if you're an arbitrator, and many of the arbitrators listening to you right now and potential arbitrator listening to us right now, can an arbitrator be a mediator?
Yes, an arbitrator can be a mediator. Yeah.
Okay, fantastic. Thank you. 2 more questions before we move on to your presentation. We're getting to 10 questions. Michael, thank you to see you from South Africa again. Very informative, very interesting. Do you believe that eventually all construction contracts will have an arbitration clause as a standard? So would you have arbitration clause as a standard in all the contracts?
I don't think so. Like I said before, it would depend on the type of project and the complexity of the project. So I don't think that arbitration should be used across all construction contracts, or that it should be made mandatory. I think, one of the traits of arbitration is that it's consensual. So parties agree to have an arbitration clause, and you don't want to take away that aspect of choice or freedom from them. Yeah. You still want to deliberately make the choice as opposed to impose that on them.
Awesome, awesome. Thank you. Henry from Nigeria, very important question. How do you mend relationship between the parties to the dispute after the ruling of the arbitration is given? So a case of maintaining the relationship over winning the argument. So how do you maintain that balance after arbitration? It's a great question, right?
Yeah, it is. Well, I think that for the most part, and that doesn't just apply to arbitration, but also to litigation, it's not really personal, right? It's about, you know, one party saying that it has a right and the other party disagreeing with that other party having a right. So it's not personal. It's more it's legal, it's contractual. It's about who is, you know, who the law sides by, that sort of thing. So I think it's a question. It's more of a choice, or you know, it's more of an effort that has to be made by both sides to understand that, you know, we are in dispute, but doesn't mean that we are enemies. We work together. You know, we used to love each other. Now we have a dispute, but doesn't mean that, you know, we can't work together again. We can try. Yeah.
Okay, excellent. We've got a question from Cabo from Zambia. I think this is a question I think, you know, it's a tricky one. How much arbitrators charge? I don't think it's a right platform, but I think it's very expensive, Cabo. They are very expensive. So Cabo's question is how much arbitrators charge their fees on an hourly rate. So this is again, it depends, Reshma, right?
It depends, yes, and it depends across arbitral institutions as well. So, for example, I know that at the FCIA, arbitrators charge at an hourly rate. This is how the cost or the fees of arbitrators are calculated. And with other institutions such as the ICC, the fees of the arbitrators determined based on the value of the dispute.
Okay. We'll take one more before we move on now, and that's from Humaid. Which region, in your experience, Middle East, Africa, Europe, Asia, Pacific, see the most number of arbitration cases? So which continent do you see a lot of arbitration cases happening?
If I'm not mistaken, there are actually a lot of surveys and reports on that, and you know, if the person who's asked this question wants to know definitely what that is, they could email me. But I think that the consensus is that most of the arbitrations in the world are happening in Europe, so in Paris or in London. Or in Switzerland, but there's a push to bring back arbitration in the countries to which they belong, and so this year there's a lot of talks going on about bringing African arbitrations back to Africa, for example, and yeah, so there's an effort being made for that to happen.
Okay, thank you. This is the last part, the part 3, which is the most interesting part, because you're talking about construction professional as well, which I'm looking forward to. So take it away, part 3, Reshma. Thank you for all your questions, and we're gonna answer. We've got about half an hour to go, so we still got plenty of time. Reshma, all yours.
Yes, Anya, this is the 3rd point. This is not part 3. So we've got 3 more points to cover. Yeah. We've got how to incorporate arbitration in your construction contracts. So, well, now that, you know, your CEO is convinced that any disputes related to your high-value construction project should be submitted to arbitration instead of the courts, she would like you to arrange for this. You know, she wants you to arrange for an arbitration agreement. As we discussed before, in order for arbitration to apply instead of court, the parties have to have a contract that says so. So in other words, they should have an arbitration agreement which replaces the default court mechanism. So the arbitration agreement, as we said, you know, there has to be an arbitration agreement, and the arbitration agreement can be within the construction contract itself, or it can be in a separate contract. And mostly what we find is that arbitration agreements are found within the construction contract. And a word of caution here, please always seek legal advice on your construction contracts and your arbitration agreements. What I'm going to do here is share with you some pointers, or you know, some tools which we use in drafting arbitration agreements, and it's more of an insight into these tools as opposed to, you know, just don't take them and copy them into your contracts, because that's not the way that it's done. Now, if your organization or your lawyer uses standard construction contracts such as FIDIC, the NEC or JCT suite of contracts, Such contracts will already have integrated arbitration clauses within them, or an option to choose an appropriate arbitration clause for your project. We'll take a couple of examples. So this is an extract from the FIDIC Red Book, which is actually the most commonly used FIDIC standard contract worldwide. It is the construction contract for building and engineering works designed by the employer, and we tend to see this contract in arbitrations over and over again. These standard contracts are used as the basis for the construction contract, and they're usually reviewed and readapted to the specific project in question and the laws applicable to the parties' contract. So this contract includes what we would call a multi-tiered arbitration clause. And what we can see here is an extract of clause 20 of the Red Book, which is the dispute resolution clause, and 20.6 contains the arbitration clause. And I'll read it for you so that we can dissect this part together.
Yeah.
So it says that unless settled amicably, any dispute in respect of which the DAB's decision, if any, has not become final and binding, shall be finally settled by international arbitration. Well, DAB stands for Dispute Adjudication Board, and what this part of the clause is saying is that prior to submitting their dispute to arbitration, the parties should first attempt to settle their disputes amicably. And secondly, they should go through a DAB process, and which is another form of dispute resolution. That's an entire other webinar. We could spend hours speaking about dispute adjudication, and we won't really be covering this today. But I think it should suffice for you to know that it is a different type of dispute resolution, and it can be binding or not binding. Now I'm going to read the second part, which says, unless otherwise agreed by both parties, A, the dispute shall be finally settled under the rules of arbitration of the International Chamber of Commerce. B, the dispute shall be settled by 3 arbitrators appointed in accordance with these rules. And C, the arbitration shall be conducted in the language for communications defined in subclause 1.4, open bracket, law and language, close bracket. Now, in this second part, the parties choose the institution through which they would like the dispute to be arbitrated. In this case, it's the ICC. The parties expressly select the number of arbitrators to decide the dispute, which is 3. And they also choose the manner of appointment of their arbitrators, which is through the rules of the ICC. And finally, they select the language of their arbitration, which is stated in another part of this contract. So as you can see, arbitration clauses can be quite complex, and it is best drafted by a lawyer to suit the specific needs of a project or of the parties. And other than dispute resolution clauses found in standard construction contracts, the different arbitral institutions also have what we refer to as modal clauses that parties and lawyers can use as a basis for drafting their arbitration agreement within their contracts. And it's possible to find these modal clauses on the websites of the different institutions or arbitral institutions in the world. And for today, I'm going to take the example of the modal clause, which is on NIAC's website. And NIAC is the Mauritius International Arbitration Center, as we saw. So I'm just going to go ahead and read this for you. Any dispute, controversy, or claim arising out of or relating to this contract, or the breach, termination, or invalidity thereof, shall be settled by arbitration in accordance with the arbitration rules of the Mauritius International Arbitration Center. And it also says that parties may consider, it's not mandatory, but parties may consider adding the following. A, the number of arbitrators shall be, and they are free to insert an odd number. B, the seat or legal place of arbitration shall be Mauritius. Now, Mauritius could also be replaced with another country. And C, the language of the arbitration shall be, they could pick the language that they want, such as English or French, or such as the other language that's appropriate. Now, going back to the first part, I'd like to highlight the use of the word shall here. And by using the word shall, using the word shall has the effect of making arbitration mandatory. And in the absence of any other contradictive clauses in the contract, this would mean that parties cannot use court as a means of resolving their dispute. They have the obligation to submit their dispute to arbitration. And if instead of shall, the word may was used, the parties would have had the right, but not the obligation to submit their dispute to arbitration. Yes, so in that case, either party to the contract would have been free to go to court if they chose to do that.
Awesome.
Yes, so we've seen a couple of examples of model arbitration clauses, and I just wanted to say that with drafting arbitration clauses, there are other particular legal considerations that have to be factored in, and they are jurisdictional considerations generally, and for example, any particular laws applicable to an arbitration agreement in the country or the jurisdiction where the arbitration will be held or where it will be enforced have to be considered. Care must also be taken to ensure that the arbitration clause does not contradict with other provisions of the contract. Right. So to illustrate the point, I wanted to give you an example of a badly drafted arbitration clause.
Wow.
And this is actually coming from a case which was heard in England and Wales. I'm just going to go ahead and read that for you. So the clause starts with law of England and Wales. In the event of any dispute between the parties pursuant to this agreement, the parties will endeavor to first resolve the matter through Swiss arbitration. Should a resolution not be forthcoming, the courts of England shall have non-exclusive jurisdiction. Now, there's a lot of things that could be said about this arbitration clause, but obviously, I'm not in court, so I'm not going to go through everything, just a few things to highlight here. And these are things that you may have already identified because we went through all the material. So firstly, it is not clear why the term law of England and Wales is mentioned at all. So, the questions that arise here are, is it intended to apply to the whole contract or to the arbitration agreement? It's not really clear. Yeah. Secondly, there's no binding agreement to refer a dispute to arbitration. Instead, there's simply a non-binding obligation of the parties to endeavor, as in to try and attempt to resolve their dispute through Swiss arbitration.
Absolutely.
And this means that they should try to resolve the dispute for arbitration, but they do not really have the obligation to. And just to add a third point, the clause provides for court litigation should a resolution through arbitration not be forthcoming. Now, it's not really logically possible to have one binding arbitration dispute resolution stage, that is arbitration, followed by another binding dispute resolution stage, that is litigation for the courts. Well, this arbitration clause, as I said, came up in a case in the Court of England and Wales. And the court concluded that there was no binding agreement to arbitrate, but merely an agreement to attempt to resolve the matter by a process of arbitration.
Thank you for this, Reshma.
Yeah, so we have another video now, just to conclude on this part.
Yeah.
Now that we've dealt with the relevance of arbitration to the construction industry and how to incorporate an arbitration agreement in your construction contract, let's hear from this gentleman who's a US attorney. It is an older video, but still very relevant to arbitration.
Yeah, I think that's a really good video. I watched that as well, so I think it's really relevant. Let's listen to this gentleman here.
In this video, I want to talk a little bit more about arbitration and some of the more nuanced aspects of arbitration. Arbitration is governed by the agreement to arbitrate that's typically found in the agreement between the parties. Generally, the American Institute of Architects agreements and other form agreements have some sort of arbitration provision built into them. Those arbitration provisions that's basically the blueprint of what the arbitration is going to look like. So In your agreement, you can specify whether you're going to have one arbitrator, 3 arbitrators, whether discovery is going to be allowed in the arbitration, whether rules of evidence are going to be followed, and so forth. I think it's very important for parties that are negotiating these contracts to bring in somebody that really knows about arbitration procedures. What's good about arbitration, what's not so good. So for instance, do you really want to allow depositions and other types of discovery? These are discovery techniques used in court, and they tend to drive up the costs substantially. One of the big advantages of arbitration is that it's quicker and it's cheaper, or at least it's supposed to be. If you bring in all of these court procedures, you may find just the opposite, that it's lengthy and more expensive. All of this should be spelled out in the agreement to begin with. Another example is whether they have 1 or 3 arbitrators. The rules of the American Arbitration Association, if you're using them as your arbitration provider, spell out when you have 3 arbitrators versus 1. Typically, it's over $1 million, you get 3 arbitrators, but you can certainly change that. The cost of arbitration is influenced by how many arbitrators you have. So the cost triples if you have 3 arbitrators. You might want to consider what the cutoff is for having 3 versus 1. It might be smart to just have 1 arbitrator no matter what the size of the dispute. Nevertheless, this is all something you should discuss with your attorney when you're negotiating the original agreement among the parties. Another issue that's important, particularly in construction agreements, is whether you want to have joinders. So for instance, you're the owner. Do you want to have a single arbitration that includes the architect, the contractor, the subcontractors, the engineers, and so on? As an owner, you might think that's a good idea. It may not be. When you're actually involved in a dispute, do you want to have the contractor bringing in all kinds of subcontractors? That's going to make this more expensive and cumbersome. These are things you can put into your arbitration agreement. Don't just take the form as it's written by the form provider. Tailor your arbitration agreement to your needs and to how you see this thing being resolved. It's important to do that, and you're going to have a much better result at the end of the day.
Okay, so back to you, Reshma. Back to you again on the final part. We've got about 25 minutes to go, so let's continue. And thank you for listening, everybody. And if you're enjoying it, everybody, can you please put your hands up? I'm really enjoying it as well, so please put your hands up for Reshma. We're already enjoying it. So Reshma, all yours. I know you've got 2 more steps, and then please proceed. So just put your video on as well, Reshma. So please bear with us. We've got about half an hour, but I think there's so much to learn, and I think this could be a workshop for 5-6 hours, but we're trying to scrum that into a couple of hours. So we can see your slide, Reshma. If you can just go to different step in construction arbitration, and then just go full slide there. Yeah, that's it. Excellent. Yeah. We just can't see you.
Actually, this is what I was trying to fix.
Okay, don't you worry. I can fix. I can see if I can put you on now. Just bear with us, and I'm going to ask you to put your video on now. So
yes, I can.
Yes, you can. Awesome.
Yes.
Okay, awesome. So we've got about half an hour, everyone. Let's push on and let's enjoy that. Thank you, Reshma.
Thank you. Thank you so much, Anil. Yes, so we've got 2 more topics to go, and we are topic 4 now. I hope you enjoyed that video, by the way. So we'll now be going over the different steps in a construction arbitration. And, we could sit here and talk about this all day. So what I'm going to do is go over it very quickly and try not to get into stuff that's too technical. Now, for the most part, the process of a construction arbitration is very similar to any other commercial arbitration. It does differ, like we discussed, in terms of the technical issues, the complexity of claims and the counterclaims, and large amounts of evidence involved, for example. Now, let's assume that we have a construction dispute. We have done our level best to resolve it amicably by making several reasonable offers to the other side, but the other side is adamant on its position. And we think that we have a good case, that we have a good chance of winning it if we go to arbitration. We have a well-drafted, valid arbitration clause, and we also followed all the mandatory pre-steps provided in our construction contract before we can commence arbitration. Now, since the other party to the contract is not agreeable to a resolution, we have no choice but to commence an arbitration in order to enforce our rights. And let's say that our contract provides for institutional arbitration through the ICC. The first step would be to file an RFA, which is a request for arbitration. Okay, and the RFA is actually a document which briefly describes the claim, the release being sought, and some other important information on the parties and the case.
Reshma, sorry, what is RFA?
RFA is request for arbitration. It's an abbreviation for request for arbitration. Yes, so I'll continue to use the word request for arbitration if that's easier for you guys.
Because in construction we have request for approval.
Oh, right. Okay.
That's right, yeah.
Okay, so yes, so we have the request for arbitration. We have to, the claimant has to submit the request for arbitration. And in case the arbitration agreement provides for 3 arbitrators in the dispute, the claimant also has to nominate their arbitrator or an arbitrator in that RFA. After that, the institution will acknowledge receipt of the request for arbitration, and it will notify the opposing party, who we call the respondent, of the claimant's request for arbitration. The respondent will then need to file an answer to the request for arbitration. And also, if they have a counterclaim, if they also are challenging the other side and then saying that they haven't done this or they owe them money, etc., etc., they can actually raise that at that time, and we call that a counterclaim. And at that stage, if there's 3 arbitrators, if there's going to be 3 arbitrators according to the arbitration agreement, they would also nominate their arbitrator. Okay, and then, yes, in the event of a counterclaim, the claimant would provide a response to the counterclaim, to the respondent's counterclaim. And then the institution will proceed to appoint the arbitrators. Okay. So just parenthesis here, the 2 parties nominate an arbitrator, and it's the institution which appoints the arbitrators, okay? And so that's the appointment of arbitrators. And once the arbitrators have been appointed, there's a case management conference. And this is basically the very first meeting amongst the parties and the arbitral tribunals, where they will decide on matters that are related to the dispute, as in what they're going to do throughout the dispute, how the arbitration is going to be conducted. So they will decide on the timetable, the rules of procedure that will be applied, whether or not there will be a hearing, whether there will be a document production stage, whether there will be experts involved in the disputes, and so on.
And Reshma, if you just go back on that one, what's the timeline for that so far?
Yeah, I had thought of doing that, but because of the time constraint, I didn't do that. Usually a party has to respond to the other side's request within 30 days. And it really depends on the rules. Okay, there are certain rules that provide for more days, 45 days. There are other rules that provide for 15 days. Okay. With the ICC, if I'm not mistaken, it is 30 days.
Thank you.
Right, so yes, so after the case management conference, 2 documents would be prepared in an arbitration. And the first one is a terms of reference, and it's abbreviated as TOR.
Yeah.
And the procedural timetable. Like I said, I'm not going to go into technical stuff, but I just thought that it would be helpful for you to know, what steps are involved and about a couple of documents that are prepared. Yeah. And these documents essentially integrate what the parties and the tribunal have decided in respect of the conduct of the dispute and the mandate of the arbitrators. So for example, in the terms of reference, it's quite common for parties to say what issues the arbitrators will decide, but that's not always the case, okay? So after the terms of reference and the procedural timetable have been issued, and the procedural timetable is actually issued with something we call procedural order number 1, but again, I'm not going to go into too much detail there. Let's move on. So after those steps have been completed, parties will file their pleadings and evidence. And usually in an arbitration, there's 2 rounds of evidence, but there can be more. And alongside the pleadings, there will be the document production phase. And if the expert reports haven't been filed alongside the pleadings, they would be filed in a separate stage alongside of the pleading stage.
Yeah.
Next, there's the hearing. There can be other steps before the hearing also, but generally, you know, in an arbitration that's going on smoothly, the parties would proceed to the hearing. There may be, you know, further submissions like a skeleton argument before the hearing. But yes, so there's the hearing. And in the hearing, the parties, arbitrators, experts, and witnesses come together to hear and test each other's case. And then after the hearing, there's closing submissions. So, you know, after testing each other's case, the parties would have gathered further information about each other's case. So they would then make submissions to the tribunal to advocate their side of the case to the tribunal.
Awesome.
And then obviously there's the issuance of the arbitral award by the tribunal.
Is that the best bit, the award?
I think so. You know, that's the reason why people, you know, parties are arbitrating. It's in order to get a decision, right? And that award communicates.
So Reshma, just a quick one. From where you started to where the award is, what's the timeline there generally?
Yeah, so generally it can take between 1 year to 2.5 to 3 years to complete. Yeah. Yeah, okay. But there's also now what we call expedited proceedings, where all of this is done within 6 months in certain, right. Yeah, it can be done, but obviously that's not conducive to all types of disputes. There are some disputes just take time because of the complexity of it. You know, the parties and the lawyers need time to, you know, go through the documents and really prepare for the case. So
this is where Reshma, record keeping is important. So your advice to all of us watching us today, for construction professionals to have the record, because you talked to me a few days ago and you said that there are companies that come with you with a file and everything is orderly and neatly, you know, bind. What's your advice to all of us watching for the award to be successful?
Yeah, so record keeping is so important, guys. It is so important, because at the end of the day, we will argue the case on the basis of documents and evidence, right? And the more organized you are with your documents, the better it is, because it's easier to navigate the facts of the disputes and also to pull up the evidence that's required to prepare the case. And you know, there's parties on both ends of the spectrum, right? Sometimes parties come to us and they are so organized and we love them because they've got everything in a folder, in subfolders, outgoing letters, incoming letters, etc., etc. And then there's others who just pile up all the documents and we have to sort through them, and that actually takes a lot of time. And you know, having organized documents can actually be extremely critical in winning a case. Yeah. Okay, so we now come to the last part of this presentation, which is also probably the most important part, given that many of you are construction professionals attending this presentation today. So what's the role of construction professionals in an arbitration? And let me begin by saying that construction professionals actually have a very significant and critical role to play in construction arbitrations. And these roles and functions are many, for example, they can be experts, they can be arbitrators, they can be party representatives, they can be a witness of fact, they can be legal representatives, and they can also be a consultant to the parties involved.
And Reshma, just a quick one. Who can be a witness of fact? Could you give us an example, please?
Yes, so a witness of fact can be anybody who's been on the construction site and has witnessed something that happened. And that is an issue in the dispute.
Okay.
So for example, if we're saying that the consultant didn't come on site on a particular day and there's no documents to evidence that, then you can get a witness who was actually there on the site on that day to write a witness, to draft a witness statement to say that I confirm that this such and such person wasn't on site on that day, and then the thing is that witness of fact can be cross-examined by the other side. So once you submit a witness statement, then the other side may ask to cross-examine the person who's actually submitted that.
Awesome, thank you.
Yeah, for the purpose of today's presentation, I'm going to go only over the first three. We can leave the other three for another webinar, or you can email me or ask me questions about that. So we'll be going over the roles of construction professionals as expert, as arbitrator, and as party in a construction dispute, party representative in a construction dispute. So I think you know that experts are becoming a routine feature now in construction arbitration, and they have an increasingly important role to play in supporting a party's case and strengthening arguments and ultimately winning a case. Well, something very important to bear in mind is that an expert, even if appointed by a party to an arbitration, should keep his independence. He's independent. And his duty, his primary duty, is ultimately to advise the tribunal independently rather than to advocate the client's position. So this duty actually overrides the expert's duty to the instructing party, even though the instructing party is paying him. Now, what's the role of an expert? Well, experts typically have a tribunal determine which party bears the responsibility for what goes wrong in a construction project. And we see different types of experts in construction arbitration. There's those who have expertise, for example, in structural issues, in delay analysis, in the determination of quantum or losses occurring as a result of a party's failure to do or not to do something. Right, so yeah, so in an arbitration, an expert's role may include, for example, the preparation of an expert report. He may also be preparing expert reports in rebuttal or in reply to the other party's expert report. They would also be called upon to give oral evidence at the hearing. So they would have to go to the hearing, and the tribunal may ask the expert questions on the report, and the expert is also open to being cross-examined by the other side. And as you can see, an expert is a very, very critical element of an arbitration, and an expert can either make or break a case. Oh. And therefore, what factors should you consider when appointing an expert? Well, these are just a few considerations, okay, and I'm going to be touching on them very briefly.
So, Reshma, what you're saying is that an expert is vital when it comes to that, because as you just said, they can make or break a case depending on how, the expertise they have being an expert.
Yes, yes, experts are very, very important in complex international construction disputes, because they actually help both the parties and the tribunal understand those complex issues that arise in arbitration.
Awesome, thank you. Just to let you know, we've got about 20-25 minutes to finish off the webinar, so we are on good for time.
Okay, awesome. All right, so what are the factors that you should consider when selecting an expert? First of all, the construction expert you're appointing must have solid expertise in the relevant subject matter of the dispute, whether it's structural, related to delay, or issues of quantum. Credibility is actually a key consideration. also, because alongside having solid expertise, the expert should be able to communicate that expertise in a convincing and credible manner. And thirdly, that expert should be able to communicate that expertise in a convincing and credible manner, yes, but at the same time, he or she should remain impartial and independent, uninfluenced by instructing counsel. And usually the more objective and independent the expert appears, the more credible they are likely to appear in the eyes of the tribunal. And therefore, it's very, very important that experts should avoid acting as advocates for the party appointing them. And they should also be encouraged, I think, to concede points where it's appropriate to do so. Right. So the next role I would like to talk about is the construction professional's role as an arbitrator. And as we said before, a construction professional may be appointed as an arbitrator in a construction dispute. There's actually an increasing tendency to appoint construction professionals or construction professionals who also have legal qualifications as arbitrators. And this is because there's many advantages in doing this. Firstly, construction professionals bring exceptional subject matter expertise and technical experience to the table, which traditional arbitrators who are legal professionals do not have. And this may lead to cost savings, as there may not be a need to appoint technical experts in the arbitration. So if your tribunal consists of both legal and technical experts, you could dispense from having an expert in the dispute, because you have that expertise already on the tribunal. It also provides for a more diverse and inclusive panel. Let's not forget that the users or the parties to construction arbitrations are likely to be construction professionals themselves. And I think they would be more comfortable in a setting where there are construction professionals involved. And the tribunal is diverse in the sense that they consist of both legal and construction professionals.
And Reshma, just a quick one on this. As we there's lots of institutions now, the RICS, the FCIArb, the FCIArb, talk about inclusion and diversity. You being a role model, being an international lawyer, how important is inclusion and diversity for the women watching you right now and all the men as well? How diversity is so important in bringing a nice arbitration case?
It's very, very important, actually, and I cannot speak highly enough or enough at all about how it's important to have a diverse set of skills. As women, we bring a different skill set to the table. Yeah. And traditionally, we know that in this profession, especially in the legal profession, the construction profession, there were not as many women. There has been a lot of improvement, obviously, but there's a lot more to be done. And yeah, so that's something that I'm very, very passionate about supporting other women into the legal profession, into the construction profession. And I'm so happy when I see women as construction professionals. Like a couple of years ago, I had a lady who came to survey a land that I was planning to buy, and I was so happy that this is happening. It's great.
Yeah. Well, thank you.
Yes. So I wanted to go back to the survey now because it's very interesting that respondents were asked to select the characteristics which they look for when selecting an arbitrator for an international construction dispute, and that's in that survey actually, and I'm quoting from there, when appointing arbitrators, the vast majority of respondents valued construction experience above all. 27% of respondents identified greater use of non-lawyer arbitrators as a defining characteristic, reflecting the importance of industry expertise in the context of construction disputes. And, that says a lot about the growing tendency for construction professionals to be appointed as arbitrators.
Yeah.
So finally, I would like to talk about the role of construction professionals as party representative. And so not all construction organizations have an in-house lawyer, and therefore construction professionals such as the project manager may be called upon to instruct the external lawyers who will be representing the organization in an arbitration. And these professionals, and they would also attend the hearing with the lawyers. So these professionals have first-hand knowledge of what has been going on site, and they are often in the best position to provide instruction to counsel, and they're also in the best position to organize the facts. Now, if you have your documents organized, you have them organized, you don't have to reorganize them. You just transfer the file.
Yeah.
Yes, but it's very, very important to have their input when it comes to factual elements and technical elements of the dispute. They also perform the function of gathering relevant documents and evidence in the case. You don't always have all the documents you need, so they are the perfect. They are in the perfect position to know where to find the documents that we need in order to advocate the case. They also provide continuous assistance to the legal counsel throughout the various stages of the dispute, and they attend the hearing along with the legal representative. Well, in my experience, I wanted to share this with you that in my experience, construction professionals are instrumental actually in explaining technical terms and concepts to their lawyers. Let's not forget that arbitration is actually a huge team effort. And if lawyers can understand these technical concepts, they can in turn break those down for the tribunal to understand. Yeah. And this has the likelihood of making the advocacy or the representation in the case more effective. And in fact, when I started working heavily on construction arbitration in Qatar some years back, I was able to pick up on the then unfamiliar concepts and technical terms related to construction thanks to two civil engineers on my team. One of them was the client's representative, who was their lead cost estimator at the time. I did invite him to this webinar. I'm not sure whether he's here or not. And the other was the partner I was working with at my law firm, who alongside being a lawyer was also a qualified civil engineer. And he had previously worked as a claim consultant. And I still recall that they were so passionate about construction that we spent hours and hours discussing about the different construction terms and concepts at the time, such as value engineering, testing and commissioning, the importance of the BOQ, the function, the importance of having functional chillers prior to the installation of certain fixtures and fittings, etc. Yeah, so yeah, it's very interesting, and I really enjoy working with, the legal team and the construction team together. I think there's a lot of knowledge sharing and experience sharing that goes on, and that can really help to further your case.
Okay.
Now, we've come to the end of the presentation, but not of the webinar. I think you may have, we can try the poll again, but
yeah, let's go back to one of your, just go back to your slide, Reshma, as we take the questions. As you just go back one to your slide. So just to the last slide you showed on the construction. Yeah, so leave that there. Let me just stop the, stop the screen. Yeah, so just, and then we'll take the question from the audience. So can we have a big round of applause for Reshma as we tackle your questions now? We've got about 17 of them, so please do not send me any more questions as I get Reshma to answer those questions quickly. So Reshma, we've got one from Yika Dambakwa. What happened when change of law clause is removed or deleted in a contract? During the course of the contract, the government introduces new law that lead to the contractors incurring more costs. So maybe changing the legislation. How will the contractor be able to recoup these costs incurred? So it's a bit tricky, but if there's a clause that has been removed, then the government came back in and could change the legislation, just like in COVID-19, with regard to increased transport costs because of social distancing. What's your view on that one?
Well, that's more of a practical. The legal solution may not be the appropriate solution in these instances. Even for the COVID-19 situation, there's a lot of issues going on where contractors are not able to meet their obligations. And a change of law is a similar situation. It's not something that the parties have control over, right? It's coming from an external source, and it can become burdensome for the parties to then absorb these additional costs. And in my view, it's always it's always very, very important to try to resolve these issues amicably as opposed to legally, because I think that you would have a better chance of continuing to, to progress the project if you opt for a practical solution to these types of problems as opposed to.
Okay, a question from a seasoned project manager, Rick. What is the significance of the use of the word agreement versus contract when referring to the relationship between parties? So again, quickly on agreement versus contract.
Well, there are two interchangeable terms unless it has been defined in the contract. So when we refer to the contract, we're also referring to the agreement between the parties. Now, if the term contract or agreement has been defined in the contract to mean that written contract, then, for example, if the agreement says, in the agreement is defined as this contract, as this written contract, then it's limited to that contract, because parties can reach agreements outside of the contract. So an agreement would encompass the whole agreement, not just what's written in the contract.
Yeah.
Whereas if defined, it would refer to just that document that is the contract or the agreement.
Okay, thank you. And just going back on Rick's question as well, doesn't the use of the layers in arbitration cases, so the layers, obviously what you've shown, pull the whole process back into court procedure?
Not necessarily, because the arbitration process is guided by the choice of the parties. And the parties have the option of adapting the process, the arbitral process, to their dispute, as in to the complexity of the dispute. Arbitration can also be done on a documents-only basis. So it's really up to the parties on how they want to conduct their arbitration. And I think that's the determining factor or the difference between court and arbitration.
Okay. Question from Yanish quickly. Would the law of the country have any influence on whether arbitration can be applied, i.e. civil or common law countries?
Yes, well, yes, as I said earlier, there's arbitration laws in different countries, and yes, whether a country is a civil law jurisdiction or common law jurisdiction can affect the manner in which arbitration is conducted and enforced.
Okay, just quickly, generally, question from Jay. What are the challenges that you face in enforcing international arbitration? So what are the key challenges that you face when enforcing international arbitration?
Well, one that I'm facing right now is the location of assets of the losing party. So, for example, you can have, and enforcement can be a big issue in international arbitration, but also in international litigation, right? So the parties do not necessarily have assets in the country in which the arbitration was held, or even in their, one may have to go to their country, to their hosting country in order to enforce an arbitration, because that's where the assets are held. So I would say that the location of assets is one important point.
Okay.
And then, and then there's also the point about what enforcement regime is applied in a country. And with arbitration, there's a convention that we call the New York Convention that helps parties to enforce their arbitration awards. And usually a country which has signed the New York Convention is considered as a more friendly, more arbitration-friendly jurisdiction to enforce an arbitration.
Okay, we've got 3 more questions quickly. Can you become an arbitrator and still carry your work as a civil engineer?
Yes.
Okay,
yes,
that's a simple one. And then we have one question from John. What is your view about combining the expertise of delay and quantum in one expert, as opposed to have 2 experts, one for delay and one for quantum analysis? John from Abu Dhabi.
Yes, thank you, John. Actually, I am in a dispute at the moment where our expert is giving his expertise on both delay and quantum. And it really depends on the expert's experience, I think. Some experts tend to specialize in delay only, and some experts tend to specialize in quantum only, and some experts can specialize in both. And it's really a question of demonstrating that expertise, and this is what I would consider before appointing an expert for both issues.
Okay, thanks, John. Thanks, Reshma. Last question is, if very important one actually, because I was going to stop there. If the contract is expired, can you conduct arbitration based on those contract clauses that has expired?
Yeah, well, generally, and this is general, the arbitration agreement survives the termination or the expiry of the contract. So generally that's the case. It's the case that even if the contract has expired or has been terminated, a party could still go to arbitration, but obviously, you know, the other clauses of the contract would have to be scrutinized and analyzed before we can decide whether that's actually the case. Anil, I just realized there were a couple of more poll questions. Did you want to go through them?
Yeah, let me just get to this quickly because we're almost there. So let me just, I want to ask, I think, again, everybody, big round of applause. We've got 5 minutes left before we finish off. So you can see the hand being raised there for you, Reshma. So thank you very much indeed for that. So I'm going to ask you a question, everybody, but we need to go back onto menti.com. So if you can see my screen, Reshma, can you see my screen? So if you go back to menti.com, maybe you can tap it in as well. So go to Menti, www.menti. Would you like or be interested in becoming an arbitrator based on the presentation today? Your honest answer would be great. And if you, so I'll go to menti.com now and type in the code yes. So already, again, wherever you are, which country as well, would be great for Reshma to see. Of course, it's fantastic to see lots of yeses coming through, but also say where you are from. So yes, / your country. So already, normally we do that on Zoom, but I had to devise another platform quickly to all those questions. So yes, from Mauritius. Yeah, Reshma, what's your thought?
No, I'm saying that's good improvisation. Well done.
So again, I just, if you can just type in menti.com and the code there. Yes from Conakry, yes from Qatar. Again, if you can just put anywhere where you are from. Yes from India. So basically, again, the presentation, I've really enjoyed it. I'm really good. Yes from Uganda, yes from Nigeria. So thank you very much indeed, everybody. Really, really appreciated that. And I think, again, it's good to get your feedback, of course. We've got yes from Canada. So yeah, thank you very much indeed. And again, this is so heartwarming for Reshma for being here with us for 2 hours and 30 minutes. So already 36 of you has put in. So thank you very much indeed. I've got 5 minutes to conclude. And then I was just gonna stop that and then we move on. So thank you everybody around the world for really being inspired by Reshma today. So I'm just gonna go back to the presentation. Reshma, the poll will have to take it on another one because we're getting to 2 hours and 30 minutes. But I wanna just finish off my slide with a final video, which everybody will enjoy. So we've got already 165 of you here. So I'm gonna share this with you. So bear with us and I'm just gonna finish off the presentation. So here we go. And you can see my slide and the presenter. So we've done that bit there. We've covered the video, quick survey as well. So just quick further reading. Everybody, Andy Hewitt, Reshma, obviously you probably don't know Andy, but you will know. And also we have Andy here on this platform on the 26th of August. Also, we'll try to get Reshma in. On the 26th of August, we'll have Andy Hewitt and the team to talk about this book, on Claim and Responses, which is a fantastic book. So please put your hands up on that one as well to have Andy joining us very soon on this one. And as Roger Noel goes on to say, the author has had a great deal of hands-on experience at the full face of preparing and responding to claim, and this oozes from the pages, essential reading for anyone who's preparing a claim for the first time. For those of us with experience aplenty, the book provides an excellent aide-memoire and will ensure that nothing is missed. I like the book and have no hesitation in recommending it to student beginners and those involved on a day-to-day basis. So we're looking Mark Watson, Andy Howitt, Paul Gibbons, Nina Howitt, and we'll get Reshma as well there to have a really explosive webinar on effective writing and presentation. Andy's book is out in July. This is the latest book from Andy, and it's FIDIC 1999 notices, talking about the red, yellow, silver book. It's actually £45 at the moment, and I'm sure the price will decrease. But the book and the forwards from Dr. Cyril there, this is a must-have and go-to book for any contractor, solicitor, barrister, engineer, and employer who uses FIDIC contract, and its formation will save time and money. All those who use it, I highly recommend this book. So another good one. And finally, we've got this nice book as well from Construction Claim from Paul Netscher, who is joining us in 2 weeks' time, talking about avoiding construction dispute. Paul goes on to say from Australia, Perth, Paul goes on to say, I've been involved with over 120 projects, and all I had variation claim, some for millions of dollars, almost doubling the project value. Variation or inevitable process with construction process. There will be changes and delays, no matter how well they're planned and executed. I've been there, I've learned it, and I'm sure Reshma as well, and many of you watching too. Yet, more than 99% of my claims settled amicably, and most of what we claim. More importantly, we completed further project with these employers. So finally, a final tribute. This was, I don't know if you've seen that one, Reshma. Let's act in good faith always, not just in COVID. So this is from Tony Bingham, a barrister arbitrator. And he talked about everything else there, and you can see the slide, but let's act in good faith always, not just COVID-19. And I'm sure you'll have a webinar on this as well in the future, where arbitration is not possibly just conflict, but it's also trying to resolve things to make sure all parties come out with a nice solution. So this is a tribute to Reshma. And Reshma, I want to share this with you and everybody else, because you've been really, I think you're one of the passionate ladies I've ever come across. So I'm going to share this with you now. And it's a video which I think is for all of us, but also a tribute to those people out there who want to share during those difficult times and try to give back. So let me share this video with you now, and then we'll finish off with a final word from Reshma. So let me just conclude on that one, and then we'll go through. And just making sure we have the screen and the sound. All right. Can you see my screen, Reshma?
Yes.
Okay, so I'm just going to play this video. Can you hear the video? Okay, here we go. Please enjoy this video for 3 minutes. thank you very much indeed as we conclude the presentation. So just back on my presentation, thank you very much indeed as well. So as Emma Watson goes on, I love learning. I'm just addicted to knowledge. It just like make me happy and keep me motivated. So we have this question here. So most of you, 100% of you have said yes. Again, my Zoom is not working, unfortunately. And this is something I wanted to share with you. Captain Sir Tom Moore. When we started the COVID, I introduced to many of you Tom Moore, who was helping the NHS raise more than 32 million sterling for NHS. He has now been recognized for walking more than 100 lap garden in Boston, Mauritania, Bedfordshire. So today is now Sir Captain Tom Moore. So thank you, Reshma. This is for you. So you basically, let me just stop sharing. We were planning this a year and a half. So a year and a half, but we didn't manage to do the presentation last year. So this is where, thank you, Reshma, for you. When I see you, I'll give that to you. Thank you very much indeed.
Thank you.
This is for Reshma and for being a role model to all of us and for sharing. I'm sure there'll be more webinar. So you've got a little Dubai tower there as well for you. So finally, take care, be safe. And this is, again, thank you very much indeed for having Reshma. So I'm going to ask a final word to Reshma. And Reshma, just quickly, your final word of advice in terms of being a role model, inclusion, diversity, and also arbitration, and the way we're trying to settle dispute amicably. So what's your final views as we conclude the webinar after 2 hours and 40 minutes?
Well, first of all, I'd like to say a huge thank you to you, Anil, for organizing this and for having me here. Thank you to everyone who's attending this webinar today. I feel very honored by your presence online with us today. And Anil, when I was watching that video, I was thinking that you are that person who's always thirsty for knowledge and who's always looking to learn, but also to share his learning with everyone. And you're organizing all these webinars. I think we should all, have a round of applause for Anil.
Thank you.
Behind all these webinars, and he's the person who got me here in the first place. And thank you very, very much for that. A couple of takeaways from that video. I think one of the things that it shows us is that you can actually achieve anything that you put your mind to. And Emma, she's somebody who loves learning. She loves so many things. And, sometimes we say that we cannot always get everything, but, some people do get everything. And it's a question of timing and being consistent about what you want. So you can achieve anything.
So Reshma, just a quick one. We've got 150 still watching you, listening to you right now. Has the arbitration, being in law, being legal, has made you a different person? So me watching you and the audience watching you consisting of girls, boys, men and women and kids, what is your advice to them into becoming a lawyer, becoming an international lawyer and becoming an arbitrator like you?
Well, I absolutely love the law. I'm extremely passionate about the law. And this is, I feel very fortunate to be able to work in the professional that I truly love. I've had an amazing journey as a lawyer. I started in London, in Mauritius, and then I moved to the Middle East. And this is where I was exposed to arbitration. And I would say, I would ask anyone who wants to follow that path, who wants to become a lawyer, who wants to become an arbitrator in the future, whether you want to do that by going through the legal path or through the construction path, feel free to get in touch. I'll be happy to share my experience so far. But what I can say is that it's very fulfilling. It's been an amazing journey so far. In terms of resolving your disputes for arbitration, I think with the situation that has, with the current situation with COVID-19, there has been a lot of delays and disruptions in projects, and we're likely to see a lot of disagreements. And a disagreement doesn't necessarily have to materialize into a dispute. So it's very important that parties try to find practical solutions to these disagreements before they set foot into, arguing or having a dispute. And I feel very strongly about resolving disputes amicably. And unfortunately, sometimes that doesn't work. So, parties have to litigate or arbitrate.
Okay, final word of wisdom from you. You being a woman, being a role model for many of the young engineers, women and young QSs, women and young architects watching you right now. What is your message working as a construction lawyer in a male-dominated industry? How do you take this and how do you inspire? Already you mentioned you met 2 civil engineers, you've learned so much. You're using all these technical words, chiller, and also already, what is your views? And as a woman, you should embrace what's up.
I think women can do anything. It's not really, women can do anything. You can be a construction professional, a lawyer, anything that you want. And I would say keep pushing. It's about girl power. So, there are a lot of role models out there, and this is how I feel inspired every day. I look up to the other women who have, achieved what they wanted to achieve, and I speak to them all the time. Because that's how, we get to learn about the journey, and, we are going to face a lot of difficulties in the process, and whether you're a man or a woman, that will happen. But keep pushing and keep going for your dreams.
And final question before we let you go. You've moved different countries. You work in England, in Dubai, in Mauritius, and a bit of in Africa. What's your advice in terms of traveling as an arbitrator? Do you recommend people to do that?
Well, yes, that's the other thing that came to my mind while I was watching the video. When this part where Emma was literally a jet setter. She's traveling all over the world and she's trying to study and act at the same time. And arbitrators and arbitration lawyers and international arbitration lawyers schedule can be that of a jet setter, because we tend to travel between different countries in order to meet our clients or represent our clients. And yeah, it's a question of being able to manage that schedule. And it took me a bit of time to be able to do that, actually. So that's
Okay.
something to bear in mind. That's something to bear in mind when you want to.
Thank you, Reshma. We have reached at 2 hours and 45 minutes of talk. We contacted you a few months ago and you've given back. So thank you to all of you watching. Can you please put your hands up for yourself and for Reshma for being here today? We've really enjoyed it, and I'm sure there'll be more to come. So thank you very much indeed, Reshma, and thank you for all your advice you've given. So thank you very much indeed. And you want to say something, or are you okay?
No. I wanted to say thank you again. Thank you to you and
all
to
right.
everyone.
Thank you. Take care, everybody. And time for lunch in Dubai and Mauritius. So thank you very much indeed. We've really enjoyed a good session. Take care. And Reshma, a quick wave to everybody in the audience. Take care and thank you very much. Bye. Thank you.